All right, it's 12 o'clock. You guys ready? Thanks for being here. It's a nice turnout for Marco. We have, 30 people or something like that coming in, so that's really a good group. For those of you that don't know why you're here, we're going to be discussing the sales contracts, the NABOR sales contracts, the as-is versus the residential improved. Most of the presentation day is going to be on the residential improved because that has a lot of the material that you need to deal with in your closings and your sales, and then we'll deal with the as-is as it relates to that. So we're going to be moving through the contracts. We're going to talk first about the differences between them. And I'm going to go through, as I said, in some detail over the residential improved. So if you have brought your phone or a computer and you want to pull up the contract, you certainly can do that. I didn't make copies of the contract for everyone. What we're going to go through section 8 is where the options come about of the residential improved. So that's where the buyer gets to decide whether they're going to do inspections or they're not going to do inspections. So if you check box A, those are the inspections as provided in standard D2A and the rights and remedies in D2B. And one thing you always need to be careful of is whenever you're working with a contract form, you need to be familiar with all the terms and what the rights are because they're different from form to form. So we'll do a presentation on the FAR contract later, and not today, but we'll do that, and that'll show you that there's a little differences between that contract and the NABOR contract, even with respect to as-is. And so if you're looking at what we're doing, we check box A, that gives the buyer the right to do inspections. We check box B under that contract, under the residential improved. That is a waiver of the inspection rights. And if the buyer checks box B, then the buyer accepts the condition of the property as is on the effective date of the contract. Now that's a big deal because the buyer doesn't get inspection rights. The buyer doesn't have the opportunity to go through and decide whether the buyer really wants to buy it or not. So if you really want an as-is contract, the residential improved, check the box for waiver. That's a true as-is contract. The buyer doesn't have the right to back out of the transaction. So what does the waiver mean? It means that the property condition on the effective date is going to be in the same condition through the contract to the closing because later in the contract, the seller under both the as-is and the residential improved is required to maintain the condition of the property in the same condition it was in on the effective date until the closing. If that clause was not in the contract, the buyer would take the risk of any loss, and believe it or not, the house burns down, the buyer still has to buy it unless that clause is in the contract. So why is that important even though we're dealing with two forms that we're all fairly familiar with? It's important because you might end up with a form that you're not familiar with. A guy from Chicago comes down and his Chicago attorney has drafted a purchase and sale agreement. It doesn't have this clause in it. The buyer signs it, and then the house has a casualty loss, and the buyer then finds out that the risk of loss transfers to the buyer under the common law when the buyer signs the purchase agreement and the seller agrees. So if you're dealing with contracts you're not familiar with, word to the wise is make sure you get somebody who can read the contract and understand it to talk to your customer. Okay? So we're going to be working through that. What does that mean? It means that the buyer still has the right to look at the property and gets to go through the property prior to closing or the date of possession, whichever is earlier, to confirm that the seller has maintained it in the same condition, and that's the walkthrough. So those of you that are involved with walkthroughs, remember that your customer is the one that should do the walkthrough. If you take it upon yourself to help by doing the walkthrough for your customer, what does that mean? You have just now become the guarantor that everything is in working condition. Has anybody here ever found an outlet that doesn't work after closing or a door that comes off the hinge or anything else? So if you don't want to pay for all those things, my suggestion is you don't personally do a walkthrough. And whatever I'm warning you about today, always ask your broker to make sure your broker agrees. But there's something to consider. So what are we going to do if we check the waiver box? One other thing you need to be careful of when you check the waiver box is there are things that we need to check out under the inspection provision that you are now waiving. Open permits, unpermitted improvements are an inspection item. They are not a title item. So if your customer checks the waiver box, they are now waiving the permit and the unpermitted improvements as an issue to be dealt with. Everybody understands that. Okay, under the inspection clause, the waiver says, hey, I take it just like it is, and that means everything that's there. There's still a survey opportunity, so you can check to see if the property does, in fact, encroach. Anybody here ever have anybody that's too cheap that's buying a $3 million home that doesn't want to pay $750 for a survey? I've had those, and I've had them blow up later on when the client finds out that the dock is built over onto the riparian line, and it's going to be a $45,000 or $75,000 repair. So one of the things to keep in mind is, as your customer is going through the contract and deciding what to sign and what not to sign, if you encourage a waiver because it's a hot market and we want to be sure that the buyer gets it because you want the seller to have any obligation, understand that you're possibly on the hook for anything that might go wrong. So be careful with that. Now, one thing to keep in mind when anybody does sign a waiver, and sellers fall into this trap, they'll want a waiver or an as-is contract because they believe if they've got that in the contract, they do not have to tell the buyer about any defects in the property. Okay? And that is absolutely incorrect. Seller retains the obligation to tell a buyer about any material defect which materially affects the value of the property and is not readily observable by a buyer. Okay, would that be a permit or a zoning issue? Yes, I think that it would. Would it be a termite infestation that you can't see? Yes, I think it would. Would it be a hole in the wall that you walk in and you can see? No, I don't think it would, because they're readily observable. Okay? But keep that in mind, and we've had those cases. We have appellate cases in Florida where the courts have had to determine that issue because sellers thought that if they've got an as-is contract, the buyer's buying it as is, they don't have to tell about anything that's wrong. So be careful with that. And if you're aware of anything that's wrong, you need to make sure that you disclose that too. Your code of ethics require you to disclose those defects. And Johnson versus Davis, which, as you know, is the 1988 Florida Supreme Court decision that threw out caveat emptor with respect to residential real estate transactions, whether there's a clause in the contract that requires a buyer to disclose any material defect that is not readily observable to the buyer, or not, under Johnson versus Davis, the seller still has that obligation and requirement. Now, why is that so important that you make sure you ask your seller if there's anything about the property that we need to disclose? Because if the buyer, after closing, finds out that there's some substantial defect with the property, do you think that the buyer is only going to sue the seller? I agree with you. I don't think that's going to happen. So the litigator will sue the realtor and the seller with the theory that the realtor was either the agent of the seller, or because NAR and Florida realtors promote you as having greater expertise than someone who just can grant access to an MLS, you're charged with greater knowledge and ability to review. I had a closing when I was first on Marco where the seller had put furring strips and wood underneath the carpet to bring it up to the baseboard because the slab was sinking. And put a toilet brush in the bathroom in the corner where you could see it. And there was about 4 to 6 inches of caulk between the tub and the tile in the bathroom. And after closing, my client became aware that the slab was sinking. So we pursued the seller and successfully got enough money to fix the problem. But I asked my client, why would you buy a house when you go in and you see there's 4 to 6 inches of caulk between the tub and the tile in the bathroom? The answer was, I'm from up north, and I just thought that's the way they built houses down here. So don't ever count on that. But the realtor in that case should have noticed those problems and had a potential liability. Fortunately for the realtor, the seller completely compensated the buyer as things turned out, but I think the realtor was on the hook there. So you don't want to be that realtor. So when you walk through a house, even with an as-is contract, and you see anything, and bear in mind, you're an expert. Well, expertise comes liability. You need to be sure you disclose that to the buyer. Now, what else does the seller warrant in connection with the contract, even if it's an as-is or if it's a residential improved? Under 2, the seller warrants that the seller has no knowledge that the property has wetlands or of the property not being suitable for residential use. So keep that in mind. There's a few properties on Marco that I think we do have wetlands. And wetlands isn't necessarily just something that has to do with water. It's something that has to do with horticulture. And they determine wetlands by having an expert go out and seeing what kind of plant life there is there. Almost like prehistoric hunting. And they come back and they say, well, it has evidence of wetlands and therefore it's wetlands. So be careful with that because that can affect buildability. The seller also warrants in the contract that the seller has no knowledge of unpermitted improvements or for which any required certificate of occupancy or certificate of completion has not been obtained, or of any existing or pending zoning code violation or proceeding. So this goes to Johnson versus Davis. It also goes specifically to language in the NABOR contract. The seller warrants that the seller has not commenced and will not commence any proceeding to change the zoning, and will promptly notify the buyer if the seller receives any notice of any effort to change zoning. Now that may not be a big issue on Marco Island, but those of you who stray off the rock from time to time may find that in other parts of the county and the state there can be zoning issues. So be careful with that. A big one that I think we're going to see more and more of is the seller warrants that there have been no past insurance claims and is not aware of any past insurance claims that will increase the cost or decrease the availability of casualty insurance. Now, with Ian just coming through, Irma a few years ago, we've got an awful lot of insurance claims that have been filed, and as most of you know, homes that don't have to be very old in order to have insurance problems being able to get insurance. So you need to be familiar with those issues. One thing we're not facing yet is that a seller that does not have flood insurance doesn't necessarily have to warrant anything about flood insurance. However, those of you here should be aware that if you don't have flood insurance on property and your buyer then wants flood insurance, your buyer's going to plug in at the new rates. There's no ramp up if there's no flood insurance on the property right now. And that's a big shock. And I have had people contact me in the past year that believe that the seller and the selling agent and the listing agent defrauded the buyer when they found out what their flood insurance rate was going to be. So be careful with that, because that won't necessarily get you into a liability, but it may get you into the wrong end of a lawsuit. So be careful to make sure that you disclose these defects that your seller may not be thinking about and perhaps your seller may not have liability on, but as a realtor and being an expert and certainly being sensitized to the insurance issues that everyone's facing in this area, flood and even casualty windstorm, you need to be on top of that with your buyers and make sure that they are aware of situation with various properties, and at least that you have encouraged them to investigate prior to signing an offer. Because if you don't, I can assure you that your best friend buyer becomes your worst enemy buyer and looks at you and says, you made all that money from the sale, you had an incentive to cheat me, and you did, and I want all the money that you got and then some more. And the law schools are pumping out enough lawyers these days, they will find somebody to take that case. Okay? So be careful with that. Okay. Now, the good news for sellers is that those are not guarantees, because remember, each one of those that I just told you that the seller says, the seller has no knowledge. That's good language for a seller, because if the buyer wants to prove that you have liability, the buyer has to prove that you had some knowledge. Now, your standard of liability is a little lower than that, because being an expert, I believe that a buyer can establish that you should have known, but you didn't. You turned a blind eye to a defect, and I think that can expose you to a possible lawsuit. Now, the good news is most of you have E&O coverage, and after the day's seminar, I'm sure all of you will check to make sure that you do have E&O coverage. Okay? But even with E&O coverage, there's a deductible, and you get to pay that under most of the brokerage arrangements. Now, all of those disclosures that we talked about are in the residential improved NABOR contract form. Does anyone here think that they're also in the as-is contract form? Because hopefully you do, because all of those disclosures are also in the as-is. So whether you're using the residential improved and the buyer has a right to inspect, you're using the residential improved and the buyer has waived all right to inspect, or you're using the as-is contract form, all of those seller representations that the seller has no knowledge of any of those defective conditions, they're in both contracts. Okay? So would it behoove you to go down that shopping list with your customer when you're taking a listing and say, are you aware of any zoning issues? Are you aware of any of these others right here? Right here, let's look at the sales contract. Just go down one at a time and say, are you aware of anything here, aware of anything here, aware of anything here? And if you do that and the seller says no, then document that. Everything you do, there's a way to do these things that you can become across very professionally to your seller, that you're gathering information because of Johnson versus Davis and the ultimate contract, which is going to require this disclosure anyway. So you ask these questions, again, subject to your broker thinking this is a good idea. Now, some of you may say, I'm not going to ask because if I don't ask, I could be like the three monkeys, I hear no evil, see no evil, and I'm off the hook. But that tends to fall down, as I said, with Florida Realtors and NAR promoting you as experts. Yes?
What if you use a seller's disclosure?
Use a seller's disclosure. That's a good way to gather information. I know some brokerage firms, some of the bigger ones especially, are requiring that. If you do a seller's disclosure form and your seller completes the form, those are helpful. It doesn't let the realtor off the hook from any knowledge the realtor has or should have. So if the seller goes through and says, which most of the ones I've seen, almost everything is don't know, don't know, don't know, don't know. I'm on sewer? No, I don't know. Do I have electricity? I don't know. So, you know, the disclosure forms are less than helpful in most cases, but I'll share with you a danger of the seller disclosure forms. One of the closings that I've had, and we've had some fun ones, one of the closings that I had, the seller completed a seller disclosure form in such great detail that you would have been impressed if you were the buyer and actually read everything. In the line with respect to the roof condition, the seller in that closing had written in roof leaks. Okay? In addition to lots of other things about the roof. Just a lot of comments every place. Didn't just check things, just lots of information. And I absolutely believe the seller was doing everything the seller could to disclose everything the seller knew. I mean, it was one of those deals that I was just like really impressed with the seller's disclosure. I represented the buyer. The buyer had a roof inspector come out prior to closing, and the roof inspector said, the roof leaks, but you need a new roof. It's completely shot. Now the question then is disclosing that a roof leaks the equivalent of disclosing that the roof is completely shot? I'd leave that up to the jury if I had to defend that case for the seller. In that case, it was years ago, we got half the cost of a new roof from the seller. I thought that was a fairly good settlement because my buyer now had a 30-year roof for half price.
Okay. Was that within the inspection period or after the inspection period?
That was so long ago that we didn't have an inspection period. We inspected all the way up to closing, okay? But it was there, okay? So there's an example of a seller disclosure. Now, what happens if in that case the seller goes bankrupt, doesn't have any dough, closed the transaction, we found out about the roof being shot after closing? Who's on the hook? Okay, it's on the hook. Buyer's on the hook, but it's in the seller disclosure form. So did the realtor read the seller disclosure form? Did the buyer read the seller disclosure form? I'm assuming, because I didn't get the information, the buyer did read it, and that the buyer thought, a roof leak, I can patch that, it's not a big deal, okay? But I don't know that for sure because we didn't have that discussion because we ended up negotiating a resolution of it. That didn't become important, and it never really got close to a lawsuit other than me threatening one. But just right. So you have liability there, but again, if the realtor sees the inspection report and doesn't discuss that and make clear that the realtor's read that and pointed that out, the realtor then is going to have to fall back on, well, the buyer should have read that. And then the buyer says, I was counting on you to help me. And you say, I was a transaction broker. Do we go to court? Well, we don't want to find out, do we? One thing that does happen when we have friction with your customers is your customer says, I'm going to send you a lot more business because I'm so happy with the way you screwed up this deal, right? And maybe not. So if for no other reason than referral business is your lifeblood to making a living in this industry, you do not want to screw those things up. So read those inspection reports, even though you don't have the obligation to do that per se, because that will keep you in good standing with your customer and may keep a deal from blowing up. Because in that deal, had we read the inspection report, we could have had that discussion long ago and under today's contract, we would have had it by request of the seller with the NABOR under the residential improved. We want you to, repair the roof or replace the roof. Seller could come back with whatever the seller is going to do, and maybe we end up with the same place. But at least we do it before the deal falls apart and blows up, and then everybody's picking on the realtor for making a mistake. So we don't want that to happen, okay? What are you telling me? No, it's switching. Okay. So we move on to what is the inspection procedure under the residential improved contract, okay? Now, everybody's aware of that, but I want to go through some of this because I sit on Legal Resources, which, as you know, is the committee that drafts the NABOR forms, and I get to hear the horror stories from the realtors on that committee about how the contracts are not used and people don't understand them. So I know that you guys are here because you understand it. Just want to be sure, but share the wealth with your fellow realtors. Under Standard D2, which is the section of the NABOR contract that deals with inspections, A is the inspection period and the inspection items, okay? So what do we do with that section? We've got a blank there, and it says that the buyer has a certain amount of time to conduct inspections unless we put something in the blank. There's a default of 15 days. Now, one of the beauties of the NABOR sales contract is that we've really gone out of our way to put a default every place we can so that if for some reason you don't fill in a blank, there's something there. I encourage you every time there's a blank in any contract form you use to fill it in, even if you're going to use the default time. So here we've got a 15-day inspection period. Why is there a 15-day inspection period? Because the folks on the Legal Resources Committee believe that that's an appropriate amount of time to be able to conduct all of the inspections that you might want to conduct. Because as you know, some of those inspections require an on-site testing and maybe send it away and then get the results back. We can't just call the inspector and have them go out and have everything done in a day. So if you fill in something less than the 15 days, be careful, and we'll talk about why that can blow up in your face. And some people were doing that during the recent surge in the prices. The buyers want to be sure they get something. They don't want to have a long inspection period. I'll show you how that can blow up in the buyer's face, okay? So the contract itself, though, provides a list of inspection items, and it's intended to include just about everything that might be inspected. That kind of makes a contract a lot longer. If you look at the contract, it's got about 2 pages of inspection provisions, but the listing of all these items that are to be inspected at lines 230 to 240 is intentionally done so that there's not any argument between the parties as to what can be inspected. Because if we say that you can inspect everything in the house, then does that include the appliance in the garage? Does that include the pool deck? We have had arguments about structural integrity doesn't apply to pool decks because it's not part of the structure of the house. Okay. Seawalls don't count because they're out by the water. Okay, so all those are in those sections, so you need to go through that. And that's a good checklist with your customer. What do they want to inspect or what do they not want to inspect? Now, anytime that your customer says, I'm not going to order all the inspections, or asks you, which probably happens more often, what inspections should I get? You all say, I don't really think you need any. It's a relatively new house on Marco Island and the builder was really good. No? What about if you go into Naples? You do that? It was Naples. Some of the places there have even more expensive homes, so we're not worried about it. Of course, anytime that you suggest somebody doesn't need anything, you've now become the guarantor that they, in fact, did not need it. I had a client who bought a lot one time, and when he came back the next season, he contacted me to tell me that someone was building a house on his lot. And I said, that's a terrific deal. You get a free house. He didn't think that was funny. I did. So we worked through the problem, and what had happened was the realtor had shown my client property based on the plat. And had just kind of overlooked that the area had been replatted. And the lot that my client bought was not, in fact, the lot that the house was not being built on, but it was a different lot altogether. Back in that time, it was an end of the canal lot. In those days, the end of the canal lots were not particularly attractive for buyers. They wanted to be on the side of the canal, not on the end, basically for docks and everything else. So my client was unhappy to find out that he bought a lot that he didn't really want, because he didn't get a survey and see what lot survey in that case would have shown the difference between a 100 by 160 foot lot on the end of a canal and an 80 by 110 foot lot on the side of the canal. But he didn't get a survey. Why? Because it was a vacant lot. Why did he need a survey for a vacant lot, right? Yeah, those days surveys were $300, so it's the way it goes. So if you tell your customer that they don't need a survey or an inspection of some type, you might as well be ready for when it turns out they did. How about radon? I think there's a social media thing. It's called Neighborhood or something like that. I see a lot of people on there complain about a lot of things, apparently. But one of the things that I've seen lately is a question: is anybody aware of any radon in any condominiums on Marco above the parking garage? Now, there's probably a reason for that request, okay? I did not answer it. But if you tell people they don't need a radon inspection, it'd probably be the one place that you find out that they brought in building materials with radon and it really needed radon, and you're now going to be the guarantor that they're going to not need that and either have to buy their place from them or remediate it. So be careful anytime that anybody asks you what inspections they need. You got to be careful in what you tell them, and I'd suggest that you tell them something in writing about they need all the inspections that they can get, because if you don't, they're going to tell you that when they find out they should have had an inspection, what are they going to say? My realtor told me I didn't need that. Okay? I've had that happen. I'll tell you another time that happens. It happens when they buy a house that's been foreclosed and the lender gives a title policy. And the person that's handling the sale says, well, you don't need an attorney because you're going to get a title policy. Okay? And that's okay. But every one of those deals, you should tell your people they need an attorney as well. Why? They're not going to hire an attorney because they're getting a title policy. But if you tell them they don't need an attorney and it turns out they do, who are they going to blame? Okay? So be careful with those things. I did have one of those things one time, and some of you heard that story. I had a client that bought a house from a bank, didn't use me at that time, and he paid way back when $165,000. Went to sell it 2 years later for $365,000, and turned out he had the worst title the title underwriter had ever seen. They offered to give him back his $165,000. I have never heard of a title underwriter saying, it's so horrible we can't fix it, we'll just give you your money. Okay? Now my client was really excited that he was going to get his $165,000 back. He was only selling it for $365,000, so he asked me, how about the other $200,000? Where's that coming from? Well, the good news was I was able to fix all the title problems and we closed the deal. Bad news was he might not have been able to do that. He'd had the title policy, $165,000. So this is another example of things that go wrong when everybody thinks it's going to be fine. Okay, so be careful with those. Okay? So if we're going to do inspections, how do we do the inspections? Well, first of all, the seller must provide access and utilities. Any of y'all had that problem? Yes. The seller doesn't want to provide access. We do have issues, especially when there's a tenant. Okay, that's an issue. You've got to work through it, but that's something usually professional realtors have to get together and make sure that happens. If you've got a listing, you're going to have a tenant, you need to get ready for that. Okay, but the seller has to provide access and utilities. Anybody here ever had a seller that's so cheap they turn the utilities off the day before closing? Okay. By the way, access and utilities have to be available for the walkthrough. Okay, so I tell my clients, do not turn utilities off till the day after closing. Okay, then you know you're okay, right? I have yet to have anybody move into any of those houses that my clients sold, turn the electricity, make sure it's still on in the seller's name, turn the AC down to 60, open all the windows and doors, and go, woohoo, we're not paying for it. So I don't think there's a lot of risk there, all right? But remind your folks that these are the kinds of things you remind your people to do or not do that avoid friction and problems, because we've all had closings. I tell my clients that it's not closed till it's closed. You got the moving van outside, it's not closed yet. I had a client one time, took all their furniture out, put it in the front yard, called me and said, starting to rain, what should I do? I said, go get a truck, get some Visqueen, cover it all up, put it on the truck. I said, why is it in the front yard? We didn't close yet, and the buyer's money is tied up. The buyer's got problems. He goes, well, I was trying to be courteous. So your customer wants to move all their furniture out in the front yard, wait for the closing to happen. Be sure that you're aware of it and suggest it might not be the best thing to do. Okay? But these are things that go wrong. Okay? So the inspections, though, they must be non-invasive, not entailing any perforation of walls or removal of any structural material unless approved in advance by the seller. Anybody here ever had a mold inspection and the guy says, we really need to get behind the drywall and see what's back there? Can't do it under the sales contract. Okay? Well, you know that. So if you're going to have a house, it's going to be sold, you know there was a mold issue, and you know the buyer's going to inspect for mold, better think about having some type of an addendum to that contract that allows an invasive test for mold. If you don't, FAR, Florida Realtors and NAR make you experts. You're helping to draft these contracts. Where's that going to fall? How much does it cost to remediate a house full of mold? Okay.
Thousands.
That's an underestimate. Tens of thousands, I think you're on that. Yes?
Bill, on the 15 days, you said they have to give access. You have 15 days, and the seller basically tells you, you know, the grandchildren are in, you can't get an inspector in for 5 days. Does it automatically extend? Because it says 15 days.
No, it does not automatically extend. It's a drop dead date in the NABOR contract of whatever date you put in the blank, 15 days. The seller delays it. I think there's a very good argument. You get more time. But that would depend on the circumstances, so that if the seller won't let you in for 5 days, or the tenant's not moving out, you can't get in until after the tenant's gone, and now you're delayed 5 days. Now you start your inspections. Well, I think it behooves the buyer to have everybody lined up ready to go on that 6th day or 5th day, whenever it might be. And if you still can't get it all done because of that 5-day delay, then I think that's when we start arguing we need to have a couple more days and we're entitled to it because you held us up, we couldn't get in. I think most of those inspections can get done if you get the inspector in on that 6th day, including the radon and the problem is when you sit back and you wait till the 6th day to make the arrangements, and that's a tough argument. Say, well, you didn't let us in for 5 days, and then we didn't start getting anybody in there, and they didn't get in there until the 12th day, so now we're entitled to 5 more days. Well, I'll make that argument, but I'm not so sure it's as successful. So I think you're better off just getting everybody geared up and ready to go. Okay. Now, if the buyer does damage the property in any way during the inspections, the buyer has to repair any damage caused by the inspection and also has to indemnify the seller from anything that goes wrong. So if somebody's accompanying the inspector and they trip and they fall down and they get injured in the property, who's going to be responsible for that? It's a buyer issue. The buyer's indemnifying the seller from anything that goes wrong with respect to the inspection. So keep that in mind. I know some buyers want to go with the home inspector and go through and do all that. That may not be a bad thing, but if they're going to bring the entourage, all those people are potential liability. And again, y'all are directly in the line of fire. You're between whoever it is and the other side. And I can't help but think that you're going to be stuck in a lawsuit. Anybody gets hurt, any property gets damaged, simply because you're there. And everybody thinks that you make lots of money without having to work for it. So, you got to be careful with that. Okay, so what are the dangers associated with these things? The defective inspection items are further defined in the contract. You can go look through that again as standard D2. And again, I remind you that anytime you're going to look at what is a defective item, we're not talking about the condition of the property per se. We're talking about what the contract says is a defect. Okay? FAR and NABOR contracts are different. Other contract forms are different. And what really becomes different when they bring a contract form from out of state. They think one size fits all in Illinois, so they'll use it down here. I'm not picking on Illinois, but it's a horrible idea to bring a contract from another state down here and try to use it. So be careful with that. It excludes items which are disclosed to and acknowledged by the buyer, which means in writing prior to the buyer signing the contract or the counteroffer. So that's a wonderful thing for a seller to do. If the seller, in my case with the roof, had disclosed to the buyer we've got a leaky roof before the contract, we probably wouldn't be arguing about it because the buyer then is on notice. The buyer has acknowledged, I'm buying a house with a leaky roof, I'm accepting that condition. And that really gets you off the hook, and that's where the inspection report can be helpful. That's why there's a line at the bottom of the NABOR inspection form, the seller defective item disclosure form, for the buyer to sign. Now, I don't know any attorneys that encourage their buyers to sign that. Okay, and that's a source of frustration for realtors because they'll have that form filled out by a seller, they'll provide it, they know that if the buyer signs off on that, anything that's on the disclosure form, the buyer's accepting the condition, but the buyer won't sign it. Okay. Well, the buyer has to sign that or sign some acknowledgement that the buyer has been given that disclosure or any other disclosure, And once that's done, then whatever the defect is that's in the disclosure, the buyer can't later complain about it because the inspection report says it's a defective item. Okay? Now, what is a defective item? It's any system or equipment that's not in working condition. And working condition is defined in the contract as operating in the manner it's designed to operate. So an air conditioner with a dirty filter is operating in the manner it's designed to operate, right? An air conditioner that's not cooling the air is not doing that. A refrigerator that's rusty, that chills the food, is operating in the manner it's designed to operate. So be careful with that. So cosmetic items, you don't want to be making claims. We've got a good form in the NABOR forms directory of the buyer's request and seller's response for defective inspection items. It's a very simple form. It's one page. It works beautifully. On Legal Resources, stories from the brokers in particular is that form is misused by many, many agents working with buyers because they list everything that's on the inspection report that says it's not perfect. And that's just not the way it works. If you read the form, the seller only has to address anything that's in the contract as a defective item that the buyer addresses in that form. So when agents fill that form out and include the laundry list of everything on the inspection report that says it's not quite right, wasting everybody's time because there's stuff on there. Now we're going to argue because now when you do that, your buyer has some belief that the buyer is entitled to have that done. And when the seller comes back and says, I will fix everything that I have to fix under the contract, and that doesn't include 8, 9, 10, 14, 19, 23, 24, 25, and 26, the buyer, it wouldn't surprise me that the buyer then looks at the realtor who is doing the deal and say, I want you to pay to fix those things. I have had people call me and say, I think you should tell the buyer, or I think you should tell my agent should pay for that. And I can tell you, I don't ever do that. What I respond is, I think you should have that discussion with your agent if you really believe that, because I think that the agent has done the job that they were hired to do and they're going to get compensated appropriately and they work hard for their money. So I'm not going to do that. If you want to talk to them, please feel free to do so. You know how many of those folks in the history of my practice have actually called the realtor and said, I think you should pay for this? None. That doesn't mean they never do, but they just don't know my practice. And why? Because if they're going to have me do it, they're happy to go ahead and try to put their hand in your pocket. But if they're going to have to do it themselves, it's not that important, okay? And most of those things aren't that important. You know, it's a broken doorknob. It's some other little thing that is inconsequential. So understand. But they'll look to you and expect you to do that under the guise of, you didn't have to work with you. You make all this money for doing no work at all. And we don't want you there, okay? So radon has to be below EPA action levels, which is 4.0 picocuries per liter. We've got lead-based paint still in an older home, 78 or older. The hazard abatement under HUD and EPA standards. What about termites? The contract says if you've got active termites or wood-destroying organisms or visible damage caused by past infestation, along with active infestation. So that's the definition of a defective termite condition or wood-destroying organism. If we've got evidence of past infestation but no damage, is that a defective condition? No. Okay, but your termite inspector will write that on the report. Okay, so be careful. Evidence of past infestation with no present damage is not a defective condition. Okay. Toxic or pathogenic mold at levels higher inside the property than outside the property is a defective condition. Okay, now understand, the presence of toxic or pathogenic mold is not per se a defective condition, only if it's at levels higher inside than outside. So go out to the Everglades where you've got lots of mold and water and things and look and see if you don't have some toxic or pathogenic mold outside, and then go inside that same property and see if the levels are higher. If they're higher inside than outside, there's a problem. It's a defective condition. Okay. Penicillium, aspergillus, and other allergenic molds are defined in the contract as not defective. Okay. And what's the most common mold that we see in Southwest Florida? Aspergillus penicillium, right? In various guises. Okay, and it comes back. But although you will be able to find a website somewhere that will say that it's a problem and it's a health hazard, 99.9% of them say it's not. It's allergenic. So it's not a defective item. So the contract defines what's defective and what not. What if you have a customer who has asthma or breathing problems? Would Aspergillus penicillin and other allergenic molds be a problem that that particular customer would think is a defective condition? And if so, then do you want to do an addendum to the contract? And if so, do you know that neither NABOR or FARBAR have an addendum that sits with that? So that's when you need to get an attorney to help you. Anything that you write, there's those blank lines at the end of the contract that are for filling in other provisions. You are allowed by law to fill in the blanks on a form contract. I always look at those lines at the end of the contract and I go, that's an awful big blank. And it's just an invitation to disaster. So you start filling things in on those blanks that you think sound really good when you fill them in. We'll only know if they continue to sound really good when the transaction closes, okay? And unfortunately, some of them don't. Good news is, I don't want to encourage you to fill those in with anything. Good news is, as in most parts of life, almost everything works out. But if it always did, we wouldn't buy car insurance, would we? We'd only buy it the day before we were going to get into a car accident. So this is all things to give protection for you, okay? Void, expired, issued, open, under review, or other building permits not finalized, and no issuance of a CO, a certificate of completion, with no further action required. That's the condition. Any of those that are open are defective conditions. Remember, under the inspection provision, how long do you have to inspect for those? However many days you put up in that blank. So you're going to give us 2 days to go check for open permits. That's what happened during the heyday of this big run-up in price, and everybody's standing in line to make offers. We're going to open all of them on Friday. We'll see who the winner is. And we're putting in there waiving inspections, 1-day inspections. Now your buyer now doesn't have a permit issue, okay? Or does. Won't know that because we're waiving that, okay? Now, any of those things that are defective, then the buyer agrees to fix or to keep the property in its condition on the effective date through the date of closing. The seller has to do that. And if the seller doesn't finish the repairs or keep the property in the condition it was in on the effective date, the contract mandates that we escrow an amount agreed upon by the parties, and if no agreement, 200% of the estimated cost of whatever it is that needs to be done without reduction for anything that's already been paid. So if they're putting a new roof on and they've paid half of the price to the roofer, we still escrow 2 times the entire roof of cost. The parties don't agree. Now I've had that happen, and I've had sellers that really have heartburn over that. So be aware that's in the contract. The other time that's problematic for you is if you've got a finance transaction, a lender is not happy to see a $300,000 escrow, okay? Yeah. And it might ruin the financing. So if your buyer has waived the financing contingency under the NABOR contract because they got a loan, and then we get down to that, and we have a mandatory escrow for repair items. Mandatory, not optional, mandatory. What happens to the deal? What happens to the deposit? If the buyer can't close, the buyer can't get a loan because we've got a mandatory escrow. The lender won't approve that, and the buyer waived the financing contingency because the realtor thought that was a good idea. Yes, sir.
Question for you, those open permit type things. So, the sellers make a representation for the contract. We don't typically look into those things in an inspection period. Aren't they title-related issues?
No.
They fall into that provision?
Permits are inspection items, not title. And they have been for a long time. And that's something that a lot of people think it's a title issue, it's going to be okay, but it's not. And so, as I said, when waiving inspections or we're going to give an unusually short period for inspections, then we're saying even if you got it to me to close and I order my search for that, and we don't do those ourselves, we hire a service to do that. We get those done, and now Collier's pretty good. Everything's available in 3 places online, but other places not so good. And for a while, Collier, we couldn't get anything from them. It took 20, 30 days. So that's a risk that's happening. The contract has an exception that as long as you've applied for your search or done whatever you have to do within 5 days of the effective date, you're not stuck with the 15-day deadline under whatever you've put in there. But that's sometimes a problem. So I just point that out because, again, all of these end up being time bombs that blow up in real estate transactions, and they fall back on realtors as being the people involved with the transaction, and you get blamed for everything that goes wrong, no matter if it's your fault or not. So I don't want that to happen to you, okay? Okay. Now, keep in mind also that 200%, as hard as that might be to believe, the 200% escrow or whatever the parties agree to escrow, and I've had them agree to escrow less than 200%. In the roof cases, I've had some where they say, well, you paid half, we'll only escrow the other half. And that's fine if the parties agree to that. That's not the cap on the seller's liability. The seller has to pay whatever it takes to fix whatever has to be fixed. So even though we have an escrow, if it costs more than that, certainly the escrow funds will be applied, and then the buyer will be going to the seller with the buyer's handout asking for money. So if you're encouraging your buyer to be reasonable and agree to an escrow of less than 200%, once again, you may be on the hook if they can't get that money easily from the seller. And we've had those happen where the seller says, nah, forget it, sue me. Okay. Well, that's good news for me since I litigate, but it's not necessarily good news for the buyer. Okay. All right. So, addition to all of those things, we've got the other things that need to be inspected under the contract, and these are all listed in addition to those things we just talked about. These are the items that have to be in good condition: the roof, ceiling, the interior and exterior doors and walls, the foundation. These are all listed, and I told you why they're listed. Swimming pool, pool spa decks. They must be structurally sound and watertight and free from wood rot. So wood rot was added to the contract a little while ago, a few years ago, because we had a lot of people that were arguing that wood rot wasn't termites. And so even though there was wood rot chewing up all the soffits and the doors, it wasn't a wood-destroying organism because only termites are wood-destroying organisms. So we had a realtor on Legal Resources that was just really excited about it, had to put wood rot in here. So wood rot is now in there to make it clear. And these, again, are things that were common sense to me, but they're screwing up transactions, so we put them in there, okay? What does the contract specifically exclude as a defective item? And this, again, is the residential improved. It excludes any cosmetic condition which is defined as an aesthetic that does not affect the working condition. Okay, so keep that in mind. That includes, and this is different from FAR/BAR, so you need to be familiar if you're using FAR/BAR or using NABOR, these contracts are different. NABOR excludes corrosion and tears and worn spots, discoloration of floor or wall covering or window treatments, missing or torn screens, nail holes, scrapes and dents, chips, caulking, pitted pool surfaces. Anybody had those on the pool inspection report? Minor cracks in windows. Do your buyers always want a brand new window because there's a minor crack? Okay. Driveways, sidewalks, pool spa decks, and garage cracks. Tile, lanai, and patio floor cracks. Cracked roof tiles, not a defective condition. Curling or worn shingles, not a defective condition. Limited roof life, as long as no evidence of structural damage or leaking. And your roof inspectors will give you that. They'll say roof's going to have to be replaced in 1 to 3 years. They do that for 2 reasons. One, they're hoping to replace the roof now. And 2, they don't want to have liability when somebody comes back later and says, you didn't tell me the roof was going to have to be replaced, and now it has to be replaced, and you didn't do a good job, and I'm going to sue you because now I have to buy a new roof. Okay. So the contract has a clause in it under the residential improved that I always remember when I represent the seller, and I always forget when I represent the buyer. There's a clause that says, no cost to repair or replace any systems and equipment shall exceed the fair market value of the item if it was in working condition. And when I teach this class, I always use refrigerators as an example of that clause. What is a used refrigerator worth? That's the limit of the seller's liability if the refrigerator is not working. Theory is, if the buyer is buying a house with a 10-year-old refrigerator, the buyer should get the equivalent of a 10-year-old refrigerator and not a brand new one. Now, where does that leave you? It leaves you with an unhappy buyer because they get $200 instead of a brand new Amana. And where do they want to get the other $1,500 from? Well, of course, from the realtor. Okay? So it might behoove you to discuss the limits of the seller's liability under the contract before the buyer signs.
Bill, use your air conditioning as an example. And the air conditioning unit's 15 years old and it's not cooling. Based on this clause here, it's saying that you're only getting credit for a 15-year-old air conditioner, which does not happen. When it's not cooling, they're always paying the full boat. You're telling me at that point you can say it's not $6,500 anymore. This air conditioning unit is 15 years old. We're going to give you $1,000 even though it's not working.
If I represent the seller, I can say that.
Yeah.
If I represent the buyer, I forget all about that.
But that's what that says.
That's what that says. And that's the basis for that clause being in the contract. And I have never, I can't say never, but I don't think that I have ever seen that argument raised as an issue in any of the closings that I've done in the past 10 years, and I know that's been in there for at least 10 years. But it's there, and I pointed out that it's there. Now, if it shouldn't be there, then you should tell me that, and I'll carry the water to legal resources. No, you cannot cross anything out in this contract. No realtor can cross anything out in the contract form. You are allowed to fill in blanks, but you cannot cross anything out. You cannot cross anything out, okay? Because when you cross it out, you're drafting. When you fill in the blanks, you're filling in the blanks, okay? So be careful with that. If your customer wants to cross out something, your customer can do that. And Lord knows, out-of-state lawyers love to do that. So if they do, they can, but you cannot. So do not be tempted to do that, to clarify or do things, because if you do that, then you're practicing law and you have a problem.
If your buyer or seller are crossing things out, you want to have them initial that.
Yeah, probably video it, you know, do it. But be careful with that, because, you know, if they do that, I do some kind of my suggestion would be some kind of documentation that this will confirm that you have crossed out, you know, lines 80 and 81, and this is.
Line blah 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 excluded from the contract per attorney review and something to protect us, the agents. I could do.
Well, see, now once you start doing that, those are the two dangerous things. We have a form in the NABOR Forms Directory, and Farber does too. It's just called an addendum to contract. It's a big blank. Well, I think that's not a blank you fill in very well. The lines at the end of the contract, as I said, I think those are far more than a blank. And you talk about issues. Now something goes wrong with whatever you've done there, and that's when it blows up. Now you've got not only an unlicensed practice of law possibility, but an ethics complaint for what you've done in drafting. So anytime you're starting to go off the reservation and use something other than a form, and NABOR has a form for almost everything. Not everything could possibly happen, but everything that we come up with in most residential real estate transactions use the form, because that's why they're there, and they're usually much better than even I would do just drafting on the fly. But when you start writing stuff is when things go wrong, and of course that's when it blows up. Then you know you're. And do they mostly go through? Sure, most of those work out just fine because life does. But you want to worry about the things that go wrong. Okay. All right. So what are we dealing with? That was the inspection period. So what's the seller have to do? The seller is only required to repair defective inspection items. So again, please be sure that you only list those on the request from the buyer. And the seller only has to repair whatever the seller has agreed to repair. Okay. So the inspections are arranged by the buyer at the buyer's expense and within the time allowed by the contract. The buyer goes through and makes sure that everything's fine or not fine and makes that request. And what's the process? The buyer then makes that request to the seller and says, hey, I want these things fixed. And this is a portion of the contract laying out this section that says here's items that are to be inspected. The buyer does that no later than 5 days after the deadline that you put in the blank for completing the inspections. Okay. Now be careful with that, because under the as-is contract, the buyer has 15 days to inspect or whatever other time that you put in there, but no additional 5 days to terminate the contract. So a lot of realtors fall into the trap of thinking they have 5 more days after the inspection deadline. They only have that in the residential improved contract, so be careful with that. And that is not changed in the contract. There's no blank to put in. We're going to make that 3 days instead of 5 days. That 5 days goes from whatever that number of days for the inspection period. So if the buyer wants the seller to fix or credit, the buyer has to give the seller a written demand, and by doing that has to also include a copy of the inspection report. And if the buyer wants a credit, the buyer has to include a copy of a proposal to remediate equal to the credit that the buyer is asking for. Okay. If the buyer doesn't make any demand, the buyer accepts the condition of the contract the property as it was on the effective date of the contract. The buyer demands items that are not included as defective, then those are can be ignored by the seller. So again, be professional, only include things on there that need to be done. Okay. So we move through those. We've got the buyer's permit elections. I told you we've got an extra period of time for that, but you only get one request for inspection, repair, defective items. Okay, only one. So you're not doing anybody a courtesy when you get the inspection report in, but the radon's not back or the permit report's not back. So you send off a request real quick because you want to make sure everything's moving along. Don't do that. Okay, talk to the attorney closing the transaction and get an update on the status of the permit search, because the permit search has to be included. Any defects with the permits has to be included with whatever it is that you're going to request under the inspection clause. Everybody understands that. You get one request. The contract says that. You only get one request. Okay? So if you shoot off something and then you get the radon back in later and you get the permits back in later, those are waived because you didn't request them. Okay? So
So the inspection's done and the time period's over and everything, nobody signs any document or anything, like goes away?
okay. If the inspections are done and the buyer makes no request, the buyer's accepting the condition of the property. Okay, now, the contract doesn't specifically make those 15 days time of the essence or the 5 days after it, but I think you ought to treat it as it is because it's pretty clear that those are important deadlines. Okay. Now, what does the seller do after getting those requests, whether it's to remediate or for a financial credit? The seller gets 10 days to respond to the buyer. And remember, you don't cross that out and put another number in. Your customer might do that, but 10 days gives the seller time to decide what they want to do, maybe do their own inspection, whatever they want to do, and they respond to the buyer. Now, if the seller doesn't respond to the buyer, that's a refusal to do anything the buyer's requested. Okay? If the seller does anything other than agree to everything the buyer requested, that is connected to a defective inspection item as defined in the contract, then the buyer has 5 days after getting the seller's response to terminate the contract and get back the buyer's deposit. Okay. Now, if those 5 days expire and the buyer does nothing, the buyer has accepted the seller's response, which means if the seller is silent, everybody understands that means no. If the buyer is silent, it means yes. Okay, so if the seller doesn't say a word, and this is a trap, this is another trap where well-intentioned realtors fall into a hole. You're negotiating. It's all working out. You're just about there. You're just a few dollars apart. And those deadlines come and go. And I've had that happen. And I wasn't involved with it until after it happened. And the seller's attorney then sends a note and says, no, we're not fixing anything. And the buyer says, what happened? I thought we had a deal. Okay? And in the one I'm talking about, the difference was between $65,000 and $70,000. Now, where do you think the buyer looked to pay the difference of $65,000 now that the seller was not going to fix, and the buyer had accepted the condition of the property because after the seller said, nothing, the buyer said nothing, which means this buyer accepts the seller's refusal. How did that look to the realtor, and how much do you think the realtor had to pay? Okay, well, I really go out of my way to try to make realtors not look bad when they screw up, but sometimes I can't do that, okay? And in that case, I explained to the buyer that it wasn't the realtor's fault that the buyer didn't respond. The buyer didn't want to have anything to do with that, and made some arrangement with the realtor, and I honestly am not aware of what the arrangement was. But I think it had something to do with all of that commission that the realtor was going to get went to the buyer, and that's how it got resolved, because I heard something to that effect, but not for sure. Yes?
You got an early example where a buyer sent in a request for repairs and it had all the weird things on it, 25, 26, and 27. Does that mean that if the seller doesn't accept everything but that, they can walk away, or where's that fine?
No. If they've requested something that's not a defective inspection item to be repaired, and the seller doesn't even respond to it, then the seller's saying, the seller doesn't have to respond to that, in my opinion, because the buyer's not entitled to ask for it. So the buyer only is entitled, in the form that I talked about, the buyer's election, the seller's response, that form makes it clear, if you read down to the very bottom, that if the seller doesn't agree to anything with respect to a defective inspection item, then the buyer can terminate. Okay, we changed the forms. It used to just say that if the seller doesn't agree to everything the buyer, and I'm paraphrasing, if the seller doesn't agree to everything the buyer requested, the buyer can terminate. And they were using that even with the as-is contract, when they would still request repairs and the seller would say no, and then they'd say, okay, we can get out of the deal then. Okay.
So you're saying that those things like marks on the wall and cracks in the glass, if those aren't negotiated up front or whatever, the seller's got to accept it. Where's that fine line at? I'm not following you.
Well, the contract lays out aesthetic, cosmetic conditions as being non-defective items, and I've read the list that's in the contract. So if it's one of those, I think you're on good grounds. But you do have to understand, and that's where an attorney really comes in handy, because you're going to look at that, and I look at it from a standpoint, what's it look like in court? And I go, how's this going to look to a judge or jury? Is that so many cracks in windows that now we've crossed the line? And I would have to tell the buyer, I think it is. You know, you got 28 windows and they're all cracked. Okay, it's going to cost $18,000 to replace them. I think that's a defect. One window, probably not. Where do we cross the line on that? I don't know. And I would tell my client that I don't know where that crosses the line. But I think 18 at $1,000 a piece probably does. One probably doesn't. Where in the middle it does, I don't know the answer to that. So then my client says, well, I'm going to go to court and find out. I go, okay, well, that's $100,000 for me. So if you really want to, but I try to talk them out of that. Okay. Okay. So as you know, I litigate, not just do closing. So, but that helps me keep people out of court, because when I tell them how expensive it is to go to court and how they're only going to get between 60 and 90% of their attorney's fees and costs, even if they win, they start getting more reasonable about trying to look for a resolution.
So again, if somebody sends me a list to my seller of 25 things that are defective, and we're looking at broken glass or marks in the wall,
Those are not defective.
and all I got to say is these aren't defective, but we will cover these or we won't cover these. Is that all you got to
Yeah, if you get a list and some of them are defects as defined by the contract and the buyer wants those fixed, and some other things, which as all too frequently happens, that are not defective inspection items, I think it's prudent to respond, these items are not defective inspection items, therefore we're not addressing them. These items are, and seller will repair all of them, or whatever the request might be. I think that would be prudent, not to just ignore them, but I think you should respond. And I think anytime you've got something like that you can just smell it, it's potentially friction, it's potentially a lawsuit, get the attorney involved and let the attorney run front for you and try to make that deal work, and talk to your customer, and they understand what's happening, and then make that, wordsmith that back and forth. The more you do, the more liability you have. So anytime that I think that, in my opinion, anytime you can offload to somebody who's another expert, it's in your best interest to do that.
And in a single family home, if you have a water heater that is 10 years old, the seller doesn't, but and it's working, the seller doesn't have the obligation to replace it.
Okay, in a single family home, if there's a 10-year-old water heater and it's working, it meets the contract definition of it's functioning the way it was intended to function. So unless there's an ordinance passed that said you have to replace every hot water heater within 10 years, like we have in some condos, now it's not a defective inspection item so much as it's just in violation of the condominium documents. So
We lost me on that $65,000 one, because I thought you said the seller had agreed to the $65,000.
they were negotiating. There was nothing in writing that said, I will give you $65,000 that the buyer could accept. The realtors were talking. And the offer on the table from the seller verbally, and you can't amend or have a contract verbally for real estate, even amending it, you can't addend it verbally, it has to be in writing, signed by the parties. So there was the discussion that it was between 65 and 70, just like if you guys call somebody and say, hey, you got a listing at the house for 2.8, will the seller take 2.7? And he goes back and says, yeah, write it up. Up north, they'd never do that. Down here, we do all these things on the phone. So, yeah. Well, then the buyer would have had the opportunity to accept it, but in that case, the buyer hadn't accepted anything, so probably still be back where we were, okay? All right, so we know how these things work now. When the buyer goes ahead and makes the request, the seller does whatever the seller's going to do. Now, we talked about, again, just like the repairs and the defective condition and the effective date condition, we've got the escrow provision, and that's mandatory, so be careful with that. The buyer doesn't have the right to pick who does the work. The buyer doesn't have the right to accompany the workman. The buyer doesn't have an extra inspection right. The buyer has the right to do the walkthrough and make sure all the things that the seller said the seller was going to fix are fixed. Okay. The buyer can't even tell the seller how to fix it. Okay, so keep that in mind. And the buyer gets one walkthrough, so everything has to pile up to the end. So in that situation, would it behoove you to have the home inspector or somebody else that's a professional do that walkthrough? I think it behooves you to do that all the time, but in that case, I think even more so. Again, that's subject to your broker, whether the broker says that's good or not, okay? Yes?
The buyer asked the seller to use licensed contractors to do the work.
No, there's no requirement in the contract that the seller use a licensed contractor. But if it's required to have a permit, then you have to have a licensed contractor to get a permit. So kind of back into that. Okay. Okay. Does the buyer have any other inspection rights? The buyer does have an inspection right, post-casualty inspection right under both the as-is and the residential improved, for the limited purposes post-casualty of making not later than 5 days after the seller notifies the buyer that there was damage and there's now safe access to the property, that the buyer then has the opportunity to make an inspection within those 5 days after the seller provides that notice. Okay. Yes?
You talked about the deficit items have been repaired. You talk about the buyer having one walkthrough. That's actually to have an inspector. You have the buyer can have his inspector come back and re-inspect the house. That's not the final walkthrough.
That is the final walkthrough. There's no additional right under the contract for another inspection after repairs are done to see if the repairs were done. The buyer has the right to come through the property for one walkthrough. And that was put into the contract because buyers were doing lots of walkthroughs with some properties to decorate, to bring my mother in, to bring my mother-in-law in, to bring my sister in, to bring my college buddy in, to bring the painter in. So some of the realtors on Legal Resources thought that was abusive, so we limited it to one walkthrough. The walkthrough is to make sure the property's been maintained as it was in the effective date, and that all repairs that the seller agreed to make have been completed.
And one final walkthrough. It's closing on Friday, on Thursday, doing a final walkthrough, or whatever. That's when you would also want to schedule your inspector to come back and confirm that all the work's been done.
Absolutely. That's why I suggested getting the home inspector to come do the walkthrough, which I think is a good idea all the time because I think it helps get you off the hook for anything that's not working right there. But that's up to you guys and your broker. Okay? Yes?
And will a FaceTime call suffice? Can you help your buyer if they're out of town on FaceTime? Is that just like us doing it, or is that?
Well,
Or they're on video? You know?
question is, can you use FaceTime and go through? I mean, you can do anything that you want, but I look at this as a minefield for liability. That anytime that you take it upon yourself to do anything, you have potential liability. And doing some type of walkthrough inspection, anything related to condition of the property, I mean, that to me just a time bomb waiting to happen. And will it be okay most of the time? Yeah. And that's the way life works. I keep saying we would not buy automobile insurance until the day before the car accident if we just knew the day, or at least we'd buy more that day, right? So the same thing here. You've got to build, in my opinion, you've got to build an operational system that protects you from the things that go wrong, not the overwhelming number of things that usually go right, even when we make mistakes. Okay. Right. So keep in mind that texts don't work. The Florida Electronic Signature Act specifically excludes texts as being a signature. So you cannot, even with Generation Z, text back and forth and create a contract, amend a contract, or make a deal. Okay, it's got to be signed. That could be signed by DocuSign. It could be signed by email. Anything in those documents, anything in those things, facsimile, those are all fine to create a contract or to change a contract or amend a contract. But any of these things we're talking about, not by text. So be very careful with that, because we've already got court cases and appellate cases where they've made it clear, say, hey, texts don't work. Okay, and if you're using text, liability is on you. Yes?
No, literally just had one come in. The buyers didn't check anything on the buyer's election and seller's response. They just wrote in on that blank line after combination, no action needed. So when the seller signs it, you still have to check A or?
Well, I think if the buyer has signed on the buyer's election and seller response form, no action needed, in my opinion, that doesn't even have to go to the seller because the buyer is just telling you everything's fine. Okay. But that, again, it's up to you and your broker. Okay. Yes, sir.
What are your thoughts on negotiating credit?
The question is, what are my thoughts on negotiating an equitable credit? Well, first, I'm not sure what equitable means, but a credit rather than, just making this credit. That's fine. But that's the danger, though, if you're negotiating. Remember my $65,000 and $70,000 arrangement where the realtors were negotiating, and I've had that happen in the as-is, too, where they're negotiating on what the buyer's going to get some, there's some repairs needed. The buyer says, hey, I still want you to fix this. I know it's an as-is contract, but I want, $50 grand, $100 grand, whatever it is. And they're real close to making the deal, and then the time for the buyer to terminate the contract goes away, expires, and the seller goes, go pound salt. I had that happen just a few months ago. It really irritated me because of the attorney on the other side being a rather skullduggerous individual. So it was kind of a sad situation, but I felt really bad for the realtor because I know the folks, at least the buyer's agent, was really working in good faith and thought they had everything close and let that 15 days go. And the 15 days ran out, and it was the 16th day that the seller said, go pound salt. Okay? So it wouldn't have surprised me if it was a trap.
Because they didn't formally respond back.
Because the buyer and the as-is had 15 days to terminate, and while they were negotiating a credit for the defects that the buyer did find, the 15 days expired. Yeah, and this was under the as-is. I'm going to get to the as-is in a minute. We'll get through that pretty quickly. So those of you that have things to do, bear with me. Okay, we'll go down. All right, so we're going to move on then, right? Where are we? See, these are good responses, right? You guys do this, right? Light bulb's out, tear it all down. Doorbell doesn't work, better ask for all new wiring, new furnace, water softener, jacuzzi. That does happen, doesn't it? I mean, I don't know. Sadly, okay? So let's go to the as-is contract. All right, as-is contract, right? I know, we're moving to it. Oh, catch up, don't worry. All right, we talked about this, right? Everything, no text. So the as-is contract, what do we got here? First, let's look at what's the same. Seller still has to maintain the property as the effective date through the closing. Buyer has the post-casualty inspection rights. Buyer has the same walkthrough provisions. Same 200% escrow if repairs or renovations are agreed to or needed at closing. And the same survey rights. Keep in mind the survey is standalone. It stands outside of the inspection provision, so the buyer always has that right. Under the current contract has up until 5 days before the closing to get the survey completed and tell the seller about any defects in respect to the survey. So what's different? And all that about the residential improvements, it's very complicated. The as-is is relatively simple. Section 8 just changes. The buyer has 15 days or whatever you put in the blank to inspect after the effective date. Now, under the residential improved, the buyer has to use a person or entity who is either licensed to repair the item that's being inspected or who is licensed to inspect. Okay? Under the as-is, they can have anybody they want to inspect. Okay? And why is that? Because the as-is is really an option contract. Right? So we don't care who they use because they don't have any right. The buyer has no right under the as-is contract to request that the seller make a repair. Okay? None at all. The only right of the buyer, and we talked about that because I've had those deals go south, the only right of the buyer is to terminate the contract and get back the buyer's deposit money. Okay? And if that deadline goes by, although it isn't specifically stated in the NABOR contract that time is of the essence, I think we have a hard time trying to argue that time was not of the essence. We will try, go to court and see what happens if there's a big enough deposit. Okay? The key here again is whatever time frame that you've put in for the buyer to conduct the inspections or whatever they're going to do to determine if they really want to proceed with that transaction, they don't have 5 extra days after that deadline to terminate. Okay? And that's a trap because a lot of people think, oh, we've got 5 extra days under the residential improved, so I've got 5 extra days under the as-is. You don't, so make sure you don't miss those deadlines. Now, when we're doing closings, we try to help make sure you don't miss those deadlines, but you've got to make sure you don't because you're handling these inspection clauses, okay? As with the residential improved and inspections, the inspections can include permits and improvements, okay? If you don't put anything substantially shorter than the 15 days, then we've got plenty of time to check for permits, et cetera, okay? But under the as-is, unlike the residential improved, where as long as we have started our search or commissioned our search for permits and open permits within 5 days of the effective date, we get as long as it takes to get the results back and then 5 days after that to tell the seller that the buyer wants something fixed. As is with the right to inspect is as is the right to inspect. You don't get extra time for open permit search. Okay, so be careful with that. So if you want to make that 0 days as is, keep in mind that's a waiver. We don't have any extra time to do permit searches. Okay. The seller is still required, as I said, to disclose any defects that materially affect the value of the property and that are not readily observable by the buyer. And with that, I close. Any other questions?
If you, so your seller comes in, does this, or your buyer comes in, does his own inspection, let's say pool heater doesn't work. We want to go back to the seller and say, look, we'll take the house, but you need to replace the pool heater, give us credit or close. You want to write that up, the attorney write up as an addendum, or write up as an addendum against his contract?
Well, it's into the as-is contract. First, you understand the buyer has no right to request that.
I've had it with buyers who will come and agree that.
Yeah, if the buyer requests that, then that would be an amendment to the contract. It could be a separate agreement, but I think an amendment is just the easiest way to do that. And if you're going to do that, and a lot of realtors do, is an as-is contract, and they still go through and do inspections and still planning on if there's something defective, make a request. And clearly, you want to have all that done as early as possible during that 15-day time frame, because we don't have the 15 days to make a request, 10 days to get a response. We've got 15 days, and if we're not done, we have to make that decision to terminate or not. Okay, so that's.
Not to put you on the spot, but as far as the permits and stuff, if I have the buyer and we're doing an as-is contract, would your office actually check for the permits and stuff?
Yeah, we actually hire a service to do that, and right now in Collier, that service takes about 3 to 5 days to get the report back to us on a regular basis. But in some areas around the state, it takes a lot longer than that. So, again, we have enough time to do that with 15 days. When we start shortening that window, if it takes a day or two for us to get the contract, then it takes us a day to order it. Then you can see the problem that we've got with timing.
I guess my point is, either contract, if we're doing inspections or whatever, we should probably reach out to your office, whatever, and also have that company start checking the inspection, checking the permits and stuff.
Yeah, under the as-is, if we're checking permits, it's just a terminate or we're out. Under the residential improved, it's a defective inspection item. So for all of you doing, with your customers doing inspections, my suggestion is do not make a request, do not have them make a request for the seller to remediate or give a credit until you have confirmed the status of the permit search, because you get the one request, and if you make a request for a new air conditioner and 2 days later we come back and find out that the Florida room was unpermitted, and we're going to have to go through a whole bunch on that, that's not going to be something we can ask the seller to do, at least not on the contract the way it's written.
I'm just afraid I'm going to miss something when I check the permit myself.
Okay, but any realtor that's going to check permitting, and I hear that periodically, I say, well, here's what we're going to do. We're going to check before we even make the offer. You've now become the guarantor that there are no problems with permitting. So if you guys want to take it upon yourself to go, I think your broker would say, do not check permitting, do not do these things, because you are now doing things other than what you are licensed to do, which is to work in connection with the sale of real property. And if you do that and stick to that, you'll make a great living. You won't get sued, hopefully. But if you start checking for permits and doing this and doing that, I think you're opening the door to liability. So be very careful doing any of those kinds of extra services, even though you're being helpful. The road to wherever is paved with good intentions, right?
Bill, so I have 2 questions. So I wasn't aware of this. So under the improved sales contract, okay, if an open permit is not picked up within that 15-day inspection period, okay, not that you would do this, but an attorney didn't run the search. On the 16th day, you went in and they took care of the air conditioning. On the 16th day, there was a open permit. You're saying at that point the seller does not have to correct it.
If there's a open permit found late in the day and it's after the 15 days, then I think that it's a problem under the contract, because your inspection's finished at 15. You have till the 20th to 20 days without changing the dates to ask the seller to make any repairs or corrections. If the buyer already requested the air conditioner be replaced, that's the request. And we find an open permit after the buyer's made that request, we're not entitled under the contract to make the seller responsible for that open permit. Can we ask for it? Sure, you can ask for anything, but can the seller tell the buyer to go pound salt? You're too late? Yes, that's the problem.
If it becomes a lien on the title, because I find this all the time, that these open permits pop up, you know, way after that 15 days, just about.
Well, open permits are not a lien on title. Open permits are not a title issue. Open permits are a liability for the seller or for the new owner because they've got an item for which they may end up having either a code problem or the next person that buys it wants that permit closed to make sure that everything's okay. So that's why it's not a title issue, and I keep emphasizing that. It's an inspection issue, and too often realtors think it's a title issue and it's going to be fine and we'll find it. It doesn't work that way. Or as long, and under the NABOR contract, as long as we've applied for the search or started the conduct of the search within 5 days of the effective date, even if it takes longer than 15 days to get it back, I can then, it's got a standalone, I can then ask for that later, okay, as long as I'm in those 5 days. So that makes it very important that you get the contract, whoever's doing your closing, right away so that they'll order that permit search, or if they do it themselves, great, because if they have to do it within those 5 days. If it's not done within those 5 days, then we don't get that second bite at the apple.
So the second question was, this was improved versus as is. So on improved, even if it's a latent defect, the seller doesn't have to take care of it. Seller can walk from the deal, correct? Say, I don't want to do it, the buyer either has to accept it or walk. So on as is, so why aren't we using the as is, which gives the buyer the most amount of leverage? Since the seller can say, I'm not going to take care of anything anyway. So versus, which is really better for the buyer?
That's a discussion for another day.
Well, that's this discussion.
Whether it's to use the as-is contract or the residential improved, that's a whole different discussion than the philosophy about how to do that. I can tell you the trend nationally is to be using as-is contracts and give buyers time to just think about it, inspect, back out. We haven't got there yet in Florida. Right in Florida, the overwhelming number of transactions are still using something like the residential improved NABOR form or the FAR/BAR contract.
But the improved really is an as-is contract for the seller. Because if I come back and say, you have mold, the seller says, I don't want to take care of it.
Well, the big difference between the residential improved and the as-is from a philosophical standpoint is the residential improved starts from the premise that the buyer can ask for repairs and the seller consider making them. The as-is contract starts with the buyer can't ask for anything, and I understand that, but that's the philosophical difference between the two. All right, any other questions? Yes, ma'am.
Do you think there will be a time in the NABOR contract where the buyer will have some time to look up insurance, or is it always going to be?
We're going to be, the insurance issue is a hot button right now, and I've requested Legal Resources to sit down and think about that. I think we're going to do that. We don't have a meeting in April. We have one in May, and I think we're going to talk about it in May. I don't know if it rises to the level of immediately trying to do some type of an addendum or a rider to the contract form, but we're going to kick that around and see what we can do with it because it has become a major issue. I agree with you on that. Okay, well, good to see you all.
Thank you, Bill.